Mr. Pittman, good morning. Mr. Pittman, you're here back for first appearance again. Your cousin, Mr. Hudson's in the courtroom, sir. Mr. Pittman, the law enforcement, I held you yesterday because I didn't feel there was probable cause in that complaint for assault. They have since amended the charge, and they've now accused you of one count of culpable negligence. What that charge is, it's a misdemeanor offense, and they're basically saying, Mr. Pittman, that you're culpably negligent for taking your mother out of the facility she was in and putting her in an unsafe environment, an inability to protect and take care of herself due to her medical or physical condition or mental health condition. That's what you're accused of. It's a misdemeanor offense. I have read this new complaint carefully. I actually went and pulled the culpable negligence statute to make sure I understood what the elements of the charge were. And there is, well, yesterday you wanted to represent yourself for first appearance purposes. Is that still the case, sir?
That is, Your Honor.
Mr. Pittman, anything you want to be heard on probable cause on the new charge of culpable negligence?
Yes, it is, Your Honor. Can I speak?
Before you say anything, let me give you this caveat. Mr. Pittman, we're being recorded. You're the defendant. Yes. If you talk about the charge itself, this recording could be played and used against you. So I would encourage you, do not talk about the charge itself, but if there's a legal argument you would like to make, I'm glad to listen, but I wouldn't talk about the allegations against you because you're the defendant and you've chosen to represent yourself, at least up to this point. So is there anything you would like to tell me about probable cause or any argument, legal argument you would like to make?
Well, I first would like to make a legal argument as far as an objection to these proceedings. Number one, I was never given my Miranda rights at any time. So I object on that ground first.
Mr. Pittman, okay, Miranda only applies to in-custody interrogations. There's no evidence of any statements they're using against you or trying to use them against you. Therefore, Miranda doesn't apply unless they're trying to use statements against you. Had you accepted my suggestion that you get an attorney, you would know that, or your attorney would know that, but that's not a valid basis to object to anything unless they're trying to use statements against you, which they're not so far. Any other points you want to make?
Well, I anticipate that they will. So I've expressed that one objection. Okay. Objection number two. Objection number two is that my name is Randall Pittman. In 2003, I'm sorry, 2007, I became a private attorney general for the state of California.
Your Honor, I'm going to object to this. This has no bearing on probable cause for this fact.
Your Honor, I have a right to speak. I have a right to speak.
And Mr. Pittman, you have the right to speak on probable cause, but that's what we're here for, is whether or not there's probable cause.
I have a right to make 3 objections. I'm just making 3 objections, and just let me do that, and then we can proceed. I'm a private attorney general of the state of California. I've been working undercover for them for about 20 years. And I am disclosing that information. So what that means is that this court has no jurisdiction over me because I'm a California private attorney
you're wasting our time. You're wasting our time. Even if you were a private attorney general, that has nothing to do with whether or not we have jurisdiction over you if you're accused of a crime. Mr. Mitchell, anything from the state regarding bond, sir?
Your Honor, we would just ask for a reasonable, Mr. Pittman, we would just ask for reasonable bond under this situation and absolutely no contact whatsoever with his mother, Willie Ruth Pittman.
Mr. Pittman, I'm going to set you the standard bond I would for just about any misdemeanor charge. That's $2,500 cash or surety. Mr. Hudson, I apologize. I didn't give you a chance to speak on Mr. Pittman's case. I know you have some things to add on her case. Anything you want to add on his case? So, Mr. Pittman, your bond is $2,500. The same set on just about every misdemeanor. It's cash or surety, Mr. Pittman. You'll use your phone in just a few minutes, sir. You post the bond, you'll be released. Mr. Pittman, 2 more things. Number one, I'm going to ask the jail to give you a notice for your arraignment date, which will be
January 5th.
January 5th at 8:30. Secondly, Mr. Pittman, you do have that still condition of no contact with your mother for the reasons I put on the record yesterday, and even more so now that you've been accused of a crime directly relating to lack of providing care for her. So you've got a condition of no contact with your mother, at least temporarily. Mr. Pittman, do you have any questions, sir?
Yes, Your Honor.
Okay.
I have paid for a 24/7 caregiver for my mother who was at the house when I was arrested. I did not know she was being arrested. If I had known, I would have made sure that the caregiver would have taken over right then.
Mr.
And
Pittman,
for you to not listen
Mr.
to
Pittman,
me-
you're commenting on the case that you're accused of, and I told you that's a bad idea. I'm going to stop you because you're going to hurt yourself is what you're going to do. You need to talk to an attorney, a real attorney. You need to talk to a real attorney, Mr. Pittman, that's licensed in
I
Florida,
don't want to be
is my
rescued
suggestion.
by white society. I'm an African
Your first
American.
appearance is completed. I'm not going to try to talk over you any longer. Have a good day, sir.
Thank you.